The Limitation of Liability Act is an admiralty action filed by vessel owners in federal court. The statute of limitations for a Limitation of Liability Act complaint filed by a vessel owner is 6 months. So they often are brought quickly after an incident. Sometimes they're brought a day or two after a tragedy. In a limitation of liability case, the vessel owner tries to limit its liability to all claimants. What that means is if there are tragically 10 people on board a vessel that die, the total amount of their damages will not exceed the post-incident value of the vessel and its freight, and that can be zero. It can be a very small fraction of the total damages sought by the individuals affected. The Titanic is a historical example of the Limitation of Liability Act being used. After the Titanic disaster, the vessel owner filed a limitation of liability case seeking to limit its liability to the lifeboats because the vessel was worthless. So essentially, this case was to deprive the claimants of their right to a jury and try to limit the absolute liability in that case to the value of the lifeboats and some other equipment they may have found. The Limitation of Liability Act has been criticized by courts as antiquated. It was passed in 1851 and remains in effect today, and it must be aggressively defended. A trial in a limitation case is a bench trial, meaning a judge trial. You don't get a jury. And that's why it's important to try to stay limitation cases in federal court so that you can pursue your claims and your case to a jury. A trial of a limitation case has two main components. First, it is the claimant's burden, the individual's burden, to show that there was vessel negligence or unseaworthiness, that the vessel owner was negligent, meaning that they had a duty, they breached that duty, it caused harm, and there was damage, or that the vessel was unseaworthy. Some component of the vessel, some equipment, did not meet its intended purpose. Then it becomes the vessel owner's burden to show a lack of privity or knowledge of the causative agents. Privity or knowledge examines the constructive knowledge of the vessel owner. You do not need to show actual knowledge. The vessel owner did not need to actually, for example, be on board a vessel and be calling all of the shots during the day in question. It's a high burden for the vessel owner to meet, and any unseaworthiness is automatically imputed to the owner. Fortunately, the recent judicial trend has been to expand privity or knowledge, meaning that it is much easier for us now to show that a vessel owner had knowledge of the causative agents of an incident. Policies and procedures at play also will be imputed to the vessel owner. For example, if the vessel had an unsafe practice or an unsafe policy that caused or contributed to the incident, this can be imputed to the owner and is a way to show the owner's privity or knowledge of the causative agents of the incident.